पॉलिसी बाजार पर 1 करोड़ रुपए का टर्म लाइफ इंश्योरेंस केवल 450 रुपए महीने से शुरू। Wow.
It's one of the most important stories out there, a growing confrontation between the government and the Supreme Court over how judges are appointed. Over the last few weeks, we have seen comments from the Law Minister and the Vice President as the Rajya Sabha Chair taking direct aim at the collegium system of appointing judges and even what the role of the top court should be. At the heart of the row is how the Supreme Court struck down a law passed by Parliament in 2016 called the NJAC, which would have given the government a greater say in judicial appointments. The Vice President, in fact, went as far as to say that the Supreme Court had disregarded the sovereignty of Parliament, while the Law Minister hit out at charges that the government sits on files to clear appointments and even criticized the courts for taking long vacations. Well, we've also heard rebuttals from the Chief Justice of India, who in fact has decided they're not going to be vacation benches constituted during the Supreme Court's winter break. Is that a result of these barbs by the Law Minister? Well, joining us now on the program to talk about the bigger ramifications of this confrontation is India's former Law Minister and Member of Parliament, Mr. Kapil Sibal. Mr. Sibal, thanks very much for being with us. What do you make of these sudden flurry of comments about judicial appointments, about the judiciary itself, which are coming from the government? Why do you think this is happening now?
Well, I can't possibly enter the minds of the government and speculate for you as to why this is happening, but the trend is quite clear. They want not just a larger say in the appointment of judges to the Supreme Court, they want the final word. And they want to be the arbiter of who is going to come to the Supreme Court and and all those who don't like, they want to make sure that they don't come and join the bench.
But the language that's been used, by the Law Minister in particular, it has irked the Supreme Court more than once in the last few weeks. What do you make of some of the strong words that he has said, even issuing a warning to the Supreme Court at one point saying that we are not going to sit silent forever?
Well, they have not been silent on many other things. Why would they sit silent on this issue? You see, this is the last citadel of freedom that they have yet to capture. They've captured all other institutions from the, pardon my saying, so from the Election Commission to the post of governors, to the vice chancellors of universities, to their own people in the ED, in the CBI, in the NIA. So and of course the media. I mean, I think that only very few channels are left who have an independent voice to raise. So they just, with the brute majority they have, they think that they can capture all institutions and do what they want. And this is just, this sort of sparring is the result of that. And I'm afraid what's been placed before the public by the Law Minister, unfortunately, doesn't represent the facts. The fact is, and the Law Minister is not a practicing advocate, he should know that a judge sits at 10:30 in the morning, sits on that chair till 1, sometimes 1:30. Then he comes back to court at 2 o'clock, sits till 4 o'clock, so 5.5 hours on one chair. Not an easy job, no politician does it. Then he goes back home, then he has to correct orders, then he has to read the files for the next day. That'll take another 4 or 5 hours. Each court has about 60, 70 matters every day. He has to concentrate on all that. And then after that, he has to write judgments. So actually 10, 12 hours sitting in that position, for somebody to say that they don't work or they don't need vacations, I'm sorry. In fact, the weekends are spent drafting judgments. Vacations are spent for the spillovers that of the judgments that have not yet been drafted. I mean, it's a 7-day job and a 365-day year.
What did you make of the Law Minister's comments that the Supreme Court shouldn't be taking up, for example, public interest litigations or even bail pleas? The Chief Justice did respond to that, saying that this is their job as a constitutional court. But what did you make of those comments?
Well, two things that I was a little surprised by. I mean, I was just figuring out how much Parliament has worked in the last 1 year, from January to December. And Parliament has worked for 57 days in that 1 year. Okay, and court works for 260 days in a year. So does the court tell Parliament, why aren't you working enough? And for PILs and the comment on PILs, I just want to tell you that a lot of the PILs are actually filed by those who are somewhat aligned to the government and their policies and their ideology. And the law officers stand up on the other side and say, no, this is a very important matter. The court should take note of it. I've seen it day in and day out. And the other PILs are for genuine public interest. And where the court finds that the PIL is motivated, the court rejects it. And that's the job of the court. PIL is an institutionalized practice ever since Justice Bhagwati's days. Has resulted in a lot of very judgments which have changed the polity of this country. Right. So I see, for the law minister to say this, I can't possibly look into the motive, but surely he's not quite aware of what's happening in court.
But let me ask you, the collegium system, I think many would agree, including former Supreme Court judges, is far from perfect. In fact, there is a call for greater transparency. Wouldn't you agree? And what do you think, therefore, is the best way forward in terms of making that process of appointing judges more transparent without giving the government a say in it?
Well, the problem is we have a Hobson's choice here. The point is that the collegium system is not a perfect system. It has many imperfections. But to give that power to the government would be disaster. And we've seen the government holding on to files, judges who have, in the high courts who've rendered judgment against them suddenly get transferred somewhere else, and their elevation is stopped. They're not given the appropriate high courts in accordance with their capabilities and seniority. So if the government chooses not to elevate a judge or appoint a person to the Supreme Court or the High Court, the government just holds on to the file. So, I mean, I would rather have an imperfect collegium system than a disastrous system in which the government is the final arbiter of appointment of judges.
But it's also a fact, Mr. Sibal, that when the NJAC bill was passed in Parliament back in 2015, you had the opposition supporting it as well. Would it be different if they tried to bring a new version of it today? Do you think that the opposition would still back it?
Well, you must understand that since 2014, the nature of this republic has changed. 2014 to 2022, India is not the India it was before 2014. So I'm afraid the opposition will have to change its position. I hope they do. I certainly be the one to persuade them to do so.
So finally, Mr. Sibal, what do you foresee as a result of this confrontation, which isn't ending anytime soon? What are the implications, for a democracy like India when you see the executive and the judiciary at loggerheads like this?
Well, quite frankly, Nidhi, we should be more concerned about the implications of what the government is doing in other areas. This is the least problematic, because I think the judges of the Supreme Court have broad enough shoulders to hold on to the constitutional position that they have articulated and enunciated. I don't think it'll be easy for the government to ride roughshod over the way the Supreme Court is functioning. I think we should be worried much more about what other things are happening in the polity of this country. We will stand firm. I think the bar will stand firm. The court will stand firm. Let the law minister say what he likes.
All right. Kapil Sibal, former law minister and, of course, senior lawyer yourself. Thank you very much for joining us on that big story. Thank you.
Thank you.
Well, as the confrontation between the government and the judiciary only gets worse, joining us now is former Supreme Court Judge, Justice Madan Lokur. Justice Lokur, thanks very much for being with us, sir. We spoke a few weeks ago when the law minister first made a series of comments that irked the judiciary, and since then, much water has flown under the bridge. As they say, a lot more has been said. What do you make of this escalation at this particular time, and why the government and even the Rajya Sabha chair, the vice president also stepping into this, why this is happening at this moment?
I would like to know, as much as you do and as much as anybody else would like to know, what is it that has provoked the law minister to make all these statements? As far as I'm aware, there is nothing that had happened. There's nothing that the judiciary had done or the Supreme Court had done which warranted, all these statements, which are, I think, completely unprovoked. So really, it's shocking, if I can say that he has launched this sort of an attack on the independence of the judiciary and on the collegium system.
But do you think that perhaps they're testing the waters to bring in a new version of the Judicial Appointments Bill, the NJAC as it was called back then, to perhaps, kind of reintroduce that in some way?
It's possible. It's possible that he may be testing the waters. But let me tell you, where the independence of the judiciary is concerned, there's no way that the government can, take away the independence of the judiciary through legislation or even through a constitution amendment. It's one of the basic structures of the constitution. The independence of the judiciary is fundamental to democracy. So if there is an attempt to take away the independence of the judiciary by whatever means, I think it's an assault on democracy.
Very strong words from you, Justice Lokur. May I ask you, though, we had this conversation last time also where you were in agreement that the collegium system is still, it lacks transparency, it is too opaque and definitely needs a rejig. How do you think that is going to be possible in order to make it a more credible and open system?
Well, it's not that the entire collegium system is opaque, right? There are some aspects that are opaque. For example, the criteria for selection is not known. All right. This is with regard to judges to be appointed to the Supreme Court from the High Court. The views of the government are also not known. Okay. What is it that the government has an objection to? They tell the collegium, but again, nobody knows what the objection is. We had that, recent incident of Justice Dipankar Datta, Chief Justice of Bombay High Court, who was recommended to the Supreme Court, I think around 24th or 25th of September. It took 2.5 months, for the government to accept the recommendation of the Supreme Court. Now, I think, there was, it was a fairly obvious selection or recommendation made by the Supreme Court. So one doesn't know what was the reason for the government to hold it back for such a long time. Even now, recently, the Supreme Court has recommended 5 judges for appointment to the Supreme Court. Again, one doesn't know, why it is being delayed. There are instances where judges from the High Court have been appointed as judges of the Supreme Court in a matter of 48 hours or in a matter of 72 hours. But now, it's just going on and on.
Are you suggesting that it's being done deliberately because the
looks
government...
like it, it looks like it. I mean, what else can be the reason? I just fail to understand what the reason is.
Justice Lokur, what do you also make of the attack on the role of the judiciary itself, with the law minister saying the Supreme Court shouldn't be hearing bail pleas, it shouldn't be hearing PILs? We did hear the Chief Justice push back on that.
Oh, yes. Why should the Supreme Court not hear bail applications? I mean, what is the reason? I mean, does the law minister want everybody to be in jail? Right? Why should public interest litigation not be taken up? After all, it's in public interest, so is he trying to say that the Supreme Court should not act in public interest? I can't figure out, what he's trying to convey.
All right, Justice Lokur, finally, if you had to look at the implications of this, we were just speaking to former Law Minister Kapil Sibal, who seemed to think that the judiciary is going to push back against this and it won't be easy for the government to ride roughshod over the judiciary. But do you see, bigger implications of this confrontation in the months ahead?
Well, I think what can happen, if this kind of a situation escalates, is that the government will take its own time to make appointments. All right, the Supreme Court may make recommendations. The government will sit over it for 2 months, 3 months, 4 months. There'll be some kind of a stalemate, which is not good either for the government or for the judiciary or for the people of India, right? So I think it's better if the government does not escalate this the present situation.
All right, Justice Madan Lokur, thank you very much, sir, for joining us on that important issue. And joining us on the program now is Supreme Court Advocate Ashutosh Srivastava. Also happy to welcome Justice Pradeep Nandrajog, former Chief Justice of the Bombay High Court and of the Rajasthan High Court. Thank you very much to both of you for being with us. Ashutosh Srivastava, as a senior lawyer practicing in the Supreme Court, how are lawyers like yourself viewing this confrontation at the moment?
First of all, if I say that, if we talk about the appointment of judges in the Supreme Court, it is dealt in Article 124 of the Constitution, which says that the President of India can appoint the judges of the Supreme Court in consultation with the Supreme Court judges, that is the Chief Justice of India. And but this issue was raised many a times, whether the consultation of the Supreme Court judges are mandatory or not. So that was decided in 1982 for the first time, when the Supreme Court itself said that the President was not bound to have the consultation of the Supreme Court judges, and accordingly the President would have appointed the judges of his own choice. And then the same decision was changed by the Supreme Court in 1993 verdict, when it said that no, the President cannot appoint like that, and the consultation of the Supreme Court judges would be mandatory for such appointment. And this is how it changed. So if I talk about the law minister, I don't think legally he has said anything wrong. Because see, as per the collegium, I'm not against collegium, but the collegium is not a parliamentary form which has been adopted, and it is also not as per the Constitution of India, if we consider Article 124 for the appointment of Supreme Court judges.
Ashutosh Srivastava, very simply,
Yes.
should the government have any say in the appointment of judges, in your view?
Yes, it is. It was already there. As per the Constitution itself, the President has.
But doesn't that compromise
And
on the
President-
judiciary's independence if the government has a say?
Then if we say like that, then we are also challenging the Constitution at the same time. See, it is, every, if we talk about whether judiciary, executive or the legislature, these are the most important pillars of any democracy.
Let me ask Justice
independent,
Nandrajog that. Do you agree with that, sir? Does it go against the Constitution itself to say that the government should stay out of judicial appointments?
Well, I'll put it like this, that prior to S.P. Gupta's judgment, which came in 1982, the process always was, there was no collegium concept. It was like a synergy between the judiciary and the government. The law minister would always have a courtesy visit to the Chief Justice, and all was working well till we had this issue during the emergency, the transfer of judges, non-confirmation of 2 judges of the Delhi High Court, and that then snowballed into this concept of whether the consultation means, what does it exactly mean? So there they said that the word consultation must mean effective consultation, and that effective consultation then got elaborated into that the government would have to act upon what the collegium of the Supreme Court recommends. That is how the whole thing transmutated itself. Now, one is going by the letter of the law. What does consultation mean? The other would be the spirit of the law, and in view of Keshwanand Bharati's judgment, that judicial independence is an immutable basic feature of the Constitution. So therefore, to say that the judiciary should be out from judges' appointment would not be correct. But yes, I was hearing what Justice Lokur was saying. The judiciary must also accept transparency. And unfortunately, when we talk about the collegium, we are only talking about the appointment of judges in the Supreme Court. What about the appointment of judges in the High Court? There, you see, I had been a Chief Justice of 2 courts. And we are seeing of lately, 50% of the names recommended by the High Court collegiums are turned down by the Supreme Court collegium. So are we saying that the High Court collegiums really don't know what they're doing? And unfortunately, the High Court collegium never knows on what ground the Supreme Court...
I was going to ask you, are you never given reasons by the Supreme Court collegium?
Never.
So there is a lot of opacity in that process.
Of course, it is. So when we say that we trust the Supreme Court collegium, are we saying that we don't trust the High Court collegiums?
But would you want to see a greater government say in the appointment of judges? Are you concerned? Are you concerned that would compromise on the independence of the judiciary?
Well, I think that, as they say, sunlight is the best disinfectant. So the judiciary must make itself transparent. And I think if the judiciary were to make itself transparent, much of this debate would go.
How do you view the Law Minister's comments then, Justice Nandrajog?
Well, I think he's going overboard. His reaction is disproportionate to what the Supreme Court is not ready to concede. They must concede. They haven't. In fact, if you see the last judgment of NJJC, they said the procedure has to be agreed upon. Now, that never got agreed upon. So we don't know on what basis we have selections being done. On what basis are we looking at the minorities representation? On what basis we are looking at the women representation? So all that is not there in public domain.
I'm going to leave it at that for the moment, but Justice Nandrajog, I think you really sort of hit the nail on the head that ultimately the judiciary would have to reform itself and to make changes to ensure the system is far more transparent for everyone so that you don't have a situation where, the government actually steps in. Thank you to you and to you, Ashutosh Srivastav, as well, for giving a more nuanced perspective to this big story.